Thank you. Thank you, fake audience. Welcome to Stand Up CLE, an island of entertainment in the boring sea of continuing legal education. I'm Mark Wooster. Over the years, I have discussed and mostly mocked many unethical lawyers, real and fictional. Some of those lawyers you probably heard of. But I have never discussed possibly the most famous American lawyer of them all, a lawyer whose name is known by millions, who is frequently mentioned to this day in law schools, even though he passed away when the Great Depression was still ongoing, before World War II had even started. I'm talking about the great Clarence Darrow. Now, you might be thinking, he's going to talk about the revered Clarence Darrow in an ethics class? What is the point of that? Clarence Darrow has an almost saintly reputation in the legal field. What's Wooster going to do? Pick on some possibly small violation Darrow committed? I'd never do that. Well, actually I would. I might even do so later in this presentation. But it turns out that Darrow had a truly dark side to his practice of law, one that has been mostly forgotten. Indeed, he engaged in tactics that were just shockingly corrupt. If a lawyer today did what Darrow did, he would certainly be disbarred and be lucky to escape jail time. Although, as it turned out, Darrow was fortunate to stay out of the Gray Bar Hotel. It is common to be nostalgic about the past. People today perceive a lot of nastiness in the world, in our discourse, and some wax on about some idyllic past when everyone was so much more civilized. But usually that past never existed, and certainly did not in the practice of law. Indeed, the routine way law was practiced 100 years ago or so was so astonishingly corrupt that calling it a justice system was truly a contradiction. It was in this cesspool that Clarence Darrow practiced, so perhaps it was no surprise that to be successful, he swam in the muck with the best, or the worst, of them. The case that got Darrow in major league trouble, almost taking away his freedom and his career, came in the midst of one of the most violent and dirtiest battles in the first part of the 20th century, the battle between union organizers and big business, which actually began in the late 19th century. Big business did not want unions in their workplaces and would use all sorts of underhanded tactics, such as bribery of public officials, including policemen, prosecutors, judges, and governors, to stop unionization. And of course, they used outright violence. Unions and union organizers fought back, often giving as good as they got. The former governor of Idaho was killed by a bomb planted by a union activist. And the office of the Los Angeles Times was bombed in 1910, killing 20 employees. At the time, the Times was rabidly anti-union. Into this maelstrom entered Clarence Darrow. Perhaps we should not be surprised he would have his reputation as a noble defender of the oppressed, while at the same time resorting to many unethical and illegal tactics, because he was a man of immense contradictions. At one time in his career, Darrow was general attorney for the Chicago and Northwestern Railway, making plenty of money. But he told a friend he felt like a hypocrite and a slave, and always cared about representing the downtrodden instead. So, supposedly, he quit his comfy job to help those downtrodden. But also, his boss and patron of the railway company had died. So maybe he really left because his career there was over. Darrow then became, among other things, a staunch defender of the union cause. He believed he was in a great battle against evil, against the oppression of workers. He said, quote, "Society is nothing less than organized injustice," close quote. He defended union activists with regularity. But he was also criticized for making a lot of money for taking on those defenses. So again, maybe he did not do it all for noble ideals. Darrow successfully defended William Haywood, a union man accused in the murder of the former governor of Idaho. So Darrow was an obvious choice to defend John and James McNamara, the brothers and union organizers accused of planting the LA Times bomb, in what would be known as the trial of the century. I should point out that Gerald Uman has concluded that at least 37 20th century trials were called the trial of the century. And Darrow was lead counsel in 4, which is either impressive or resume inflation, depending on your point of view. But in this trial of the century, Darrow committed many ethical violations of the century, which I will detail a little later. But first, we should address why would the supposedly noble Darrow engage in so much underhanded behavior? And not just in this case, but in other cases he handled before. Most likely because, as I alluded to before, the practice of law more than 100 years ago was truly a sordid affair. Darrow was not going up against noble prosecutors who strictly adhered to the rules. Rather, prosecutors in his day had as little respect for the rules or the law as Darrow showed. Let's take a look at what the prosecutors in the McNamara case did. After the bombing, the mayor of Los Angeles hired private investigator William J. Burns to find the culprit. That's right, the government hired a private investigator. This was actually common in the late 19th, early 20th centuries. It was also quite controversial, but happened all the time. The investigation was also funded by the National Erectors Association. That's not relevant to anything. I just wanted to point out that there actually was an organization called the National Erectors Association. Private investigator Burns right away had a suspect. He thought the LA Times bomb was very similar to one used in the bombing of a bridge that he thought was committed by John McNamara of the Structural Iron Workers Union. Burns pursued this angle, and when payments from the city dried up, he continued on his own, borrowing $10,000 to do so, because he was hoping to collect a $100,000 reward. When he found out that one Orty McManigal was apprehended in Detroit with a suitcase full of dynamite, Burns had McManigal taken to Chicago, where he questioned him and got him to confess that he had been hired by John McNamara to plant dynamite bombs at dozens of anti-union work sites around the country, and that the LA Times bombing was the work of John's own brother, Jim. Burns was accused of using the third degree to get McManigal to confess, but Burns claimed he persuaded him by appealing to his love of his family and a promise that the prosecution would go easy on him. One could see that Darrow at his side would doubt that Burns' charm was the key to the confession. Now that Burns had evidence, he had to get the McNamaras to California for trial. Under the law, that should have been an issue. The U.S. Constitution says that, quote, a person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime, close quote. The Supreme Court held that this clause, as the wording made clear, applied only to persons who are alleged to have committed a crime in a state and then fled to another state. If you never left the state, logically, you can't be found to have fled to that state. So, if they are never in the state which is charging them with a crime, they cannot be extradited. Thus, if someone conspires in Utah to plant a bomb in California, but never comes to California, then California cannot extradite that person. So prosecutors, law enforcement, and other government officials figured out a method other than extradition to get out-of-state defendants before their courts. You may have heard of this method. It has been used for numerous purposes over the centuries. It is called kidnapping. That's right. Law enforcement officials or private investigators acting on their behalf would illegally capture an accused and sneak him across state lines to be tried. What would the Supreme Court think of that? Well, in Mahon versus Justice, which reached the Supreme Court in 1888 and is found at 127 U.S. 700, a man named Mahon was accused of murder in Kentucky. Mahon was in West Virginia. Kentucky filed proceedings in West Virginia seeking to extradite Mahon. And Kentucky sent a man named Phillips to receive Mahon upon his surrender by the state of West Virginia. But apparently Phillips had a dinner reservation back in Kentucky they didn't want to miss. So he and his men simply kidnapped the accused, brought him back to Kentucky, where he was put in jail and brought before the Kentucky courts. The governor of West Virginia was somewhat displeased with this violation of his authority and his state's sovereignty, so he filed suit in federal court to have Mahon sent back. The Supreme Court said, "Sorry, Governor, Nothing we can do here. Quote, assuming, what is not conceded, that the fugitive has a right of asylum in West Virginia, the state of Kentucky has passed no law which infringes upon that right, or upon any right or privilege or immunity which the accused can claim under the Constitution of the United States. The law of that state which is enforced is a law for the punishment of the crime of murder, and she has merely sought to enforce it by her officers under process executed within her territory. She did not authorize the unlawful abduction of the prisoner from West Virginia. Close quote. The court did say that, quote, the arrest of Mahan and his abduction from the state were lawless and indefensible acts, for which Phillips and his aides may be justly punished under the laws of West Virginia. Close quote. Well, I'm sure that made Mahan feel all better about the matter as he was rotting in jail. And by the way, do you really think that Kentucky was going to turn over the kidnappers to West Virginia? Although Kentucky didn't authorize the kidnapping, clearly its law enforcement was not racked with guilt about it, as they gladly took custody of Mahan and prosecuted him. So, what are the odds that they would turn Phillips over to West Virginia for trial in the kidnapping? I'd say around 0. Maybe West Virginia should have sent people into Kentucky to kidnap Phillips and try him for the crime of kidnapping Mahan. And then Kentucky could have sent agents into West Virginia to kidnap those who kidnapped Phillips. And then West Virginia could have sent agents in Kentucky and, well, you see where this is going. We know states often have rivalries with other states, but this could have taken that to a whole new level. Apparently that didn't happen, because I have never heard of the deadly Kentucky-West Virginia Mahan kidnapping feud. Now, a behind-the-scenes moment. After I wrote this joke regarding the lack of a Kentucky-West Virginia kidnapping feud, I looked a little more into Mr. Mahan, the man who was kidnapped, whose full name was Pliant Mahan, to find a photo of him to use. And I found out the crime Mahan committed was that he and his brother, along with Pliant's father-in-law, who was named Valentine Hatfield, murdered a man named Tolbert McCoy. Yes, this case was part of the great Kentucky-West Virginia feud between the Hatfields and the McCoys, one that almost led to the two states sending in their militias against each other. Truth can be stranger than humor. And in case you're interested, here's the photo I found that supposedly is of Pliant and his brother. Anyway, regardless of the origins of this case, the law of the land was that kidnapping was an effective, red tape-free method of getting a suspect into court. And in the ironically named case of Mahan versus Justice, justice won by breaking the law. I mean, to be fair, Abner Justice, the county jailer, who was just the pro forma named defendant, didn't actually break the law. It was others who broke it, and he just happened to be the jailer. But it's ironic that the named defendant was Justice, and the defense won, because arguably justice was not served here, and, oh, never mind. As bad as all this sounds, it actually could and did get worse. At least the governor of West Virginia was upset about the violation of law in his state. Let's go back to the murder of the former governor of Idaho, which I referenced before. The investigation of that murder was led by a Pinkerton detective, who was brought into the case by, wait for it, the Chief Justice of the Idaho Supreme Court. That's right, you had a judge running the investigation of the crime. And not only that, that justice was also running for governor of Idaho as a Democrat. He hired the detective because he thought association with Union radicals could hurt his election chances, and he wanted the perpetrators convicted before the election. The Judicial Code of Ethics did not exist then, but spoiler alert on what I'm going to discuss in a few minutes. If it did, this was an ethical violation. Anyway, the detective, named McParland, thought he knew who committed the crime. However, 3 of the men he suspected as part of the conspiracy did not plant the bomb, and were not in Idaho when it was planted or went off. They were in Colorado at the time, and still were there. So McParland decided to go to the tried and true method of kidnapping, blessed as it was by the Supreme Court of the land. But his method took this to a whole new level, maybe even to more than 11. He was not just too content to on his own sail off to Colorado and kidnap the suspects. Unlike Garth Brooks, he had friends in high places, specifically the governors of Idaho and Colorado, who apparently had little regard for their duties to obey and enforce the law. McParland got the governor of Idaho to sign extradition papers, falsely claiming that the three men were in Idaho at the time of the crime. Then the governor of Colorado made sure law enforcement of Colorado would do everything they could to evade the rights of the accused. The matter made its way to the Supreme Court in the case entitled Pettibone v. Nichols, 203 U.S. 192, in 1906. This is how a Supreme Court justice described the abduction. Quote, "The agent of the state of Idaho arrived in Denver Thursday, February 15, 1906. But it was agreed between him and the officers of Colorado that the arrest of the accused should not be made until sometime in the night of Saturday, after business hours, after the courts had closed and judges and lawyers had departed to their homes, that the arrest should be kept a secret, and the body of the accused should be clandestinely hurried out of the state of Colorado with all possible speed, without the knowledge of his friends or his counsel, that he was at the usual place of business during Thursday, Friday, and Saturday, but no attempt was made to arrest him until 11:30 p.m. Saturday, when his house was surrounded and he was arrested. Moyer was arrested under the same circumstances at 8:45, and he and accused thrown into the county jail of the city and county of Denver. It is further alleged that, in pursuance of the conspiracy, between the hours of 5 and 6 o'clock on Sunday morning, February 18th, the officers of the state and certain armed guards, being part of the forces of the militia of the state of Colorado, provided a special train for the purpose of forcibly removing him from the state of Colorado. And between said hours, he was forcibly placed on said train and removed with all possible speed to the state of Idaho. That prior to his removal, and at all times after his incarceration in the jail at Denver, he requested to be allowed to communicate with his friends and his counsel and his family, and the privilege was absolutely denied him. The train, it is alleged, made no stop at any considerable station, but proceeded at great and unusual speed, and that he was accompanied by and surrounded with armed guards, members of the state militia of Colorado, under the orders and directions of the Adjutant General of the state." Close quote. Of course, the Supreme Court would never tolerate such rank illegal evasion of the Constitution, correct? Here's a clue for you. The description of the abduction that I just read is from the dissent. That's not a good sign. The majority didn't really care much about those facts. Its basic holding was to tell the accused, "Them's the breaks." It cited the law that says that once the state has got its man, it can try the accused, even if he had been kidnapped, and concluded that such rule applied. And the perfidy of the governors? Here's what the court had to say, in an opinion by Justice Harlan. Quote, "In this connection, it may be well to say that we have not overlooked the allegation that the governor and other officers of Idaho well knew at the time the requisition was made upon the governor of Colorado that Pettibone was not in Idaho on December 13, 1905, nor at any time near that date, and had the purpose in all they did to evade the constitutional and statutory provisions relating to fugitives from justice. To say nothing of the impropriety of any such facts being made the subject of judicial inquiry in a federal court, the issue thus attempted to be presented was wholly immaterial, even were it conceded, for the purposes of this case, that the governor of Idaho wrongfully issued his requisition, and that the governor of Colorado erred in honoring it and in issuing his warrant of arrest. The vital fact remains that Pettibone is held in Idaho in actual custody for trial, under an indictment charging him with crime against its laws, and he seeks the aid of the circuit court to relieve him from custody, so that he may leave that state and thereby defeat the prosecution against him without a trial. In the present case, it is not necessary to go behind the indictment and inquire as to how it happened that he came within reach of the process of the Idaho court in which the indictment is pending. And any investigation as to the motives which induced the action taken by the governors of Idaho and Colorado would, as already suggested, be improper as well as irrelevant to the real question to be now determined. It must be conclusively presumed that those officers proceeded throughout the affair with no evil purpose and with no other motive than to enforce the law." Close quote. It was so nice of the court to say at the beginning of this paragraph that it would not overlook the allegation that the government of Idaho outright submitted lying legal documents to effectuate this. Nice of the court to say it, but of course not what it did, since at the end of the paragraph, the court had already forgotten what it had said at the beginning of the paragraph, and then it had to presume the governors were both honorable civil servants, just honestly enforcing the law. Guess the court should have written shorter paragraphs so it could remember at the end of the paragraph what it said at the beginning. Thus, the Supreme Court endorsed kidnapping by private citizens and government officials actively participating in such kidnappings. By the way, note the dates involved in that case. Pettibone was arrested in early 1906, and his appeal was decided in the Supreme Court by the end of 1906. Nowadays, if Pettibone was arrested, say, at age 25, he would be collecting Social Security by the time the Supreme Court issued an opinion. Anyway, there was no official code of ethics back then for lawyers. But I think we can say that if a lawyer participated in such a scheme, that lawyer would be in violation of the rules of ethics. For example, ABA Model Rule 8.4, a favorite of stand-up CLE, states that many kinds of conduct are unethical. Here are three that come to mind when one hears about the kidnapping shenanigans of our ancestors. Quote, "It is professional misconduct for a lawyer to commit a criminal act that reflects adversely the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Engage in conduct that is prejudicial to the administration of justice." Close quote. Helping authorities kidnap suspects by issuance of papers containing blatant lies. Getting government officials to accept such lies when they know they are false. Arresting people based on these false allegations and depriving them of their day in court have the advantage of violating all those sections. I would say being part of a kidnapping plot reflects adversely on one's honesty, trustworthiness, or fitness as a lawyer. Doing it by lying on official documents is definitely conduct involving dishonesty, fraud, deceit, and misrepresentation. And no doubt, it is prejudicial to the administration of justice. It is designed to completely evade the justice system. But there is no record of anyone involved in any of these kidnapping schemes, lawyer or non-lawyer, being punished in any way for these violations of the law. Of course, kidnapping was not the only weapon used against unions and their supporters. Pinkerton detectives were often not really detectives, but enforcers who literally busted heads of strikers. Detectives often infiltrated unions and instigated members to commit violence so as to taint the union cause. Bribing jurors was an activity many prosecutors loved. Another tactic favored by the government against unions was placing informants into the defense counsel's camp. During the Haywood case that Darrow defended, the one where he obtained the acquittal of a man accused in the murder of the former governor of Idaho, a Pinkerton detective was placed into the defense camp. Once again, the governor of Idaho was involved. He was not only aware of this deception, he received the informant's detailed reports on defense actions and strategy. But if you think that was bad, just wait. He sent 5 of the reports on to someone else, bragging, quote, "The informant has reported to me every day, and I have absolute confidence in him. His work has been of extreme value to us. He has so fully gained the confidence of the attorneys for the defense that he has been put in full charge of the work of polling the county for the jury that will try the Haywood case next month." Close quote. And guess who was that someone he sent that missive to? Theodore Roosevelt, who at that time was holding a little office called the President of the United States. So the corruption and illegality of the fight against unions by government officials and employees went to the very top. Judges also were often part and parcel of these illegal activities, engaging frequently in ex parte communications, which even back then were viewed as wrongful. I already told you about the Chief Justice of the Idaho Supreme Court actually hiring detectives to investigate the murder case, and how the Idaho and Colorado governors were in on the kidnapping. Well, the Chief Justice of the Colorado Supreme Court was also part of the plot, being briefed ex parte on it by the chief Idaho detective, and giving advice as to how to get the accused out of state before they could get to court. And in that appeal of the case, which I described above, the lead lawyer of the prosecution in that appeal before the Supreme Court, claimed to have had a long talk with Justice Harlan ex parte and told him some facts that he thought would have a good effect. You know, the Justice Harlan who wrote the opinion of the court. Of course, if all that happened today, these acts would constitute major violations of numerous rules for judicial conduct, wouldn't they? As I said, ex parte communications with parties before a court were no-nos even in those wayward days. Today, there are explicit violations of the ABA Model Code of Judicial Conduct, Rule 2.9, which says that, quote, a judge shall not initiate, permit, or consider ex parte communications, or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending matter, close quote. Likewise, the Code of Conduct for United States Judges, Canon 3A4, says that, quote, a judge should not initiate, permit, or consider ex parte communications, or consider other communications concerning a pending or impending matter that are made outside the presence of the parties or their lawyers, close quote. There are certain exceptions, none of which applies to a Supreme Court justice chatting up a lawyer about a case that lawyer has before the court. But the Code of Conduct for United States judges does not apply to Supreme Court justices, the only federal judges so accepted. So, even if Harlan were here today and engaging in such an ex parte communication, he technically would not be violating any Code of Judicial Conduct, because no justice is bound by any such rule. It's good to be a U.S. Supreme Court justice. However, while there may not be a technical rule binding on justice, it would clearly be unethical and could be grounds for impeachment and removal, the only remedy actually available to punish unethical but not illegal behavior by a Supreme Court justice. How about the Chief Justice of the Idaho Supreme Court hiring a detective to investigate a murder? If you look through the ABA Model Code of Judicial Conduct, it is hard to find a rule directly on point prohibiting this. Probably because on the committee writing these rules, there were no historians expert on this transgression by the Chief Justice of Idaho, and probably no one imagined a judge doing such a thing. Still, there are some rules in the Model Code that do seem to apply, even if they are not right on the nose. For example, there is Rule 3.1, entitled Extrajudicial Activities in General, which says that a, quote, judge may engage in extrajudicial activities, except as prohibited by law or this code. However, when engaging in extrajudicial activities, a judge shall not participate in activities that would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality, close quote. I think a reasonable person would think that hiring an investigator to investigate a crime would undermine a judge's independence, integrity, or impartiality. Indeed, one would have to be quite unreasonable to believe otherwise. And the law doesn't let unreasonable people make decisions for us. Yeah, right. Also, remember the Chief Justice hired the detective as part of his campaign for governor. Canon 4 of the Model Code says, quote, a judge or candidate for judicial office shall not engage in political or campaign activity that is inconsistent with the independence, integrity, or impartiality of the judiciary. I think hiring a detective to solve a case so as to advance one's candidacy for governor is political or campaign activity, and we already established that it was inconsistent with the independence, integrity, and impartiality of the judiciary. Also, Rule 4.5, titled Activities of Judges Who Become Candidates for Non-Judicial Office, says, quote, upon becoming a candidate for a non-judicial elective office, a judge shall resign from judicial office unless permitted by law to continue to hold judicial office, close quote. I'm not sure what law would permit a justice to stay in office while a candidate for governor. And even if the justice had not officially announced his candidacy yet, he was so far along, I think if that rule had applied, he would have been in violation of it. You do have the rule against ex parte communications, but those apply to matters pending or impending before the judge. There was no case in front of the Idaho Supreme Court. I guess there was the possibility that it could make its way there, so that could be enough. But it's not a slam dunk that it violated that ethical rule. But if all that doesn't prohibit what the Chief Justice of Idaho did, you still have Rule 1.2 of the Model Code, titled Promoting Confidence in the Judiciary, which says, quote, "A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety." Close quote. Such conduct by the Chief Justice seems damn improper and does not promote confidence in the independence, integrity, or impartiality of the judiciary. I am sure the Chief Justice of Idaho's actions would be considered unethical under today's rules. And the conduct of the Chief Justice of the Colorado Supreme Court, who gave advice on how best to kidnap the suspects, that one's easy. See the very first rule, Rule 1.1, Compliance with the Law, which says, quote, "A judge shall comply with the law, including the Code of Judicial Conduct," close quote. Conspiring to kidnap is not complying with the law. Now, back to the McNamara case. Remember, I was actually talking about that like 10 hours ago? Detective Burns thought he knew who committed the crime, knew they were not in California. So, with the blessing of those numerous Supreme Court opinions, rounded up some minions and kidnapped his suspects. One of the suspects was arrested in Indianapolis, presented to a judge with extradition papers signed by the governors of California and Indiana. Guess it wasn't only the governors of Idaho and Colorado who like to conspire to break the law. Don't you love it when states get along? The accused asked for time to get a lawyer, but was instead whisked off to California. So this was the swamp Darrow was immersed in when he took these cases. During his Haywood case, he found out about the double agent. So he was well aware of the government using that nefarious strategy. He, of course, knew about his clients being kidnapped by government employees with the assistance of elected officials. He also was well aware that the other side would bribe jurors and witnesses and take any other nefarious actions they could to win. So, when he took the McNamara case, one could see how Darrow would feel that anything goes. And indeed, the prosecution played their fair share of dirty tricks. I'm not sure they added up to be the same quantity of dirty tricks that Darrow played, if one is to believe the attorney in charge of the federal probe of the LA Times bombing conspiracy, as quoted by Gerald Ullman in his Fordham Law Review essay on this case. This was how the federal attorney described what Darrow did. Quote, 2 jurors bribed, 2 witnesses paid to get out of the country, 2 witnesses paid to testify falsely, a corrupt scheme to destroy certain physical evidence in the possession of the state authorities, the corruption of practically every employee of the Los Angeles County Jail who came in contact with the McNamaras, complicity in a scheme of associates of Darrow to get Mrs. Kaplan out of state, she being the wife of one of those indicted of the Times murder and still being secreted, the hiring of George Beam, uncle of Ordie McManigal, to induce the latter to repudiate his confession on the personal guarantee of Darrow that McManigal would be made a free man, and other minor irregularities almost too numerous to mention. Close quote. I've talked about a lot of real-life lawyers who were ethically challenged, but wow, I don't recall any litany like that by any lawyer in their entire career, much less one case. And this by one of the most revered and beloved lawyers in American history. And while there were no rules of ethics for lawyers in place at this time, there was something called criminal law. And a lot of this, if it happened, and most of those who've examined this case think it did happen, violated a lot of those laws. The one alleged activity that landed Darrow in scalding beyond boiling hot water was the allegation that he bribed a juror. Darrow's chief investigator, Burt Franklin, allegedly approached a juror and offered a bribe. The juror reported this to the district attorney, and he, of course, was outraged. Only the government was entitled to bribe jurors. As an aside, the reason the juror contacted the district attorney was that he was personal friends with him. Yes, they allowed a friend of the DA to be on the jury in a criminal case. I told you this was a seedy time for the law. And this also shows the ineptitude of Darrow's team. If you are going to pick a juror to bribe, don't pick one who is actually friends with the other side. The police set up a sting and observed Franklin delivering $4,000 to the juror, 2 blocks away from Darrow's office. After making the payment, Franklin walked 1 block in the direction of Darrow's office before being arrested right in front of Darrow himself, who had just walked to that very intersection after receiving a phone call in his office. By itself, pretty bad, but not conclusive. They didn't have Darrow himself actually passing money to the juror, just meeting his own investigator after a bribe was delivered, not before. But after being arrested, Franklin turned on Darrow and testified against him. However, he was not exactly a perfect witness. He admitted on the witness stand that prosecutors had promised him immunity. He had had his fines paid. And he had met covertly with California's robber barons, who promised to reward him if he testified against Darrow. So, in a trial where Darrow was accused of bribery, the main witness against him was bribed to testify. The jury returned a verdict of not guilty in only 34 minutes. Why? First of all, the jury probably just wanted to get out of there. Darrow was famous for giving some of the longest closing arguments of any lawyer in history. In the Leopold and Loeb case, Darrow's closing lasted 12 hours. And in another of his famous trials, he spoke to the jury for 7 hours. That's a combined 19 hours for 2 arguments, almost as long as the average Academy Awards show. I'm sure any jury would vote however was necessary in order to get Darrow to stop arguing to them. Maybe that's why it took them only 34 minutes to reach a verdict. The second reason might be the judge that Darrow drew. He was certainly fortunate in that. After the verdict was announced, when Darrow was surrounded by the jurors and members of the gallery, congratulating him, the judge came up and shook his hand as well, saying, quote, "Hundreds of thousands of hallelujahs will go up from as many throats when they hear this," close quote. Darrow then told the judge he would like to visit him at his home, to which the judge gladly assented. I'd say a criminal defendant's chance of victory rises substantially if he gets a judge like that. By the way, I think you might conclude from my earlier discussion on the duties of judges that would be an ethical violation today. But aren't we glad to know that judges were willing to act in an unseemly manner for the union side as well as the anti-union side in those days? The third reason, and the one most observers of this case pinned down as the reason of the jury letting Darrow off the hook, was Darrow's argument that he was just fighting fire with fire. The prosecution was using every underhanded trick in the book. He had no choice but to fight back. As he said, quote, Suppose you thought I was guilty. Suppose you thought so. Would you dare to say by your verdict that scoundrels like the district attorney should be saved from their own sins by charging those sins to someone else? Now, gentlemen, I'm going to be honest with you in this matter. The McNamara case was a hard fight. Here was the district attorney with his sleuths. Here was Burns with his hounds. Here was the Erectors Association with its gold. A man could not stir out of his home or out of his office without being attacked by these men, ready to commit all sorts of deeds. Besides, they had the grand jury. We didn't. They had the police force. We didn't. They had organized government. We didn't. We had to work fast and hard. We had to work the best we could, and I would like to compare notes with them. Close quote. Darrow was also accused of passing $500 to a prosecution detective to obtain information about the prosecution's investigation of the McNamaras. Darrow argued, quote, "Of course I did not pass $500 in the elevator, but if I had just as much right to give that $500 for that purpose as I would have to buy $500 worth of hogs, just exactly. I was doing exactly what they were doing, what Burns admitted he was doing, what was done in all their cases, what Sam Brown says they did when he testified that they filled our office with detectives. And here comes this wonderful man, so honest, so pure, so high, so mighty, District Attorney Ford, who says that the state has a right to do that, who says the state has a right to put spies in the camp of the criminal, but the criminal hasn't the right to put spies in their camp. Isn't that wonderful, gentlemen? Here's a contest between two parties in litigation. The prosecution has a right to load us up with spies and detectives and informers, and we cannot put anyone in their office. Now what do you think of that? Do any of you believe it?" Close quote. So this is the two wrongs make a right defense. Or, more accurately, a boatload of wrongs at each side make a right defense. I guess Darrow had a point. If you look through the ABA rules, you can clearly see that it says that a lawyer is free to violate those rules and the law if the other side is already doing so. And let me find it right here. It's right. Oh, wait, I forgot. That's not the law at all. Nor is it part of the ethical rules. See, no matter how bad the other side in your case may act, you are expected, indeed required, to obey the law and the rules of ethics at all times. If Darrow today committed the acts he was accused of in the McNamara case, he of course would be in gross violation of the ethical rules. He violated many laws, and while not every violation of the law is also an ethical violation, but every one Darrow violated in this case qualifies as one. Bribing jurors, for example, is a clear violation of Rule 3.5, impartiality and decorum of the tribunal, subsection of A of which states that, quote, a lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by law, close quote. Paying a juror $4,000 to vote your way is a means prohibited by law. California Penal Code Section 92 states that, quote, every person who gives or offers to give a bribe to any judicial officer, juror, referee, arbitrator, or umpire, or to any person who may be authorized by law to hear or determine any question or controversy, with intent to influence his vote, opinion, or decision upon any matter or question, which is or may be brought before him for decision, is punishable by imprisonment in the state prison for 2, 3, or 4 years. Close quote. I'm not sure that that exact law was in place when Darrow was trying the McNamara case. But if not, it was something similar, as he was charged with it. Bribing a juror is also a violation of ABA Model Rule 8.4. It is a criminal act that reflects adversely on one's honesty, trustworthiness, or fitness as a lawyer. It is conduct involving dishonesty, fraud, deceit, and misrepresentation, and no doubt is prejudicial to the administration of justice. Hopefully, you are all aware that having a juror decide a case based on a bribe is not how justice is supposed to be administered. By the way, notice that California Penal Code also makes it illegal, among other things, to bribe an umpire. So be careful when you're on the baseball field. How about bribing an insider on the prosecution to get inside information? Surprisingly, I could not find an ABA rule that directly addresses this kind of behavior. There is ABA Model Rule 3.4, titled Fairness to Opposing Party and Counsel, which you think would talk about this, but there's nothing in there about trying to infiltrate the other side. Maybe they never thought a lawyer would try that, even though the most famous lawyer in America in history was accused of doing so, decades before the model rules were drafted. And the governor of Idaho did it and bragged about it to the President of the United States. In any event, I'm certain that every state bar would find that this conduct is a type prohibited by Rule 8.4. A lawyer knows that trying to get a person to violate the attorney-client privilege and other confidential interests of the opposing party is dishonest, interferes with the administration of justice, and is just plain bad. So don't think you can get away with it because it's not specifically covered. And of course, it can also be a crime, as Darrow found out. So don't do it! So, as I said, Darrow was acquitted of bribing a juror, but he was not in the clear. Remember, in the litany of wrongs committed by Darrow, the first one was that he bribed 2 jurors. Yes, there was a second juror who was allegedly bribed. It was claimed that Darrow, through his investigator, also bribed the first juror seated in the case. In reporting on the acquittal in the first case, the New York Times said it was believed Darrow would not be tried in the second indictment. But while that may have been fit to print, it was not accurate. The prosecution did not give up and tried Darrow on this charge, resulting in a hung jury, 8-4 for guilty. Many think Darrow came closer to conviction in this case than the previous trial, because in this case, Darrow claimed in oral argument that the McNamaras committed no wrong when they bombed the LA Times, which alienated the jurors. His co-counsel in the first case had stopped him from making that argument, but he was ill and not available in the second case and couldn't stop Darrow. So Darrow was not always the greatest legal mind. Prosecutors were going to try him again, but finally threw in the towel. So Darrow got out of this with his freedom preserved, but how about his reputation? Many of his friends were not surprised or even especially offended. One wrote, quote, If by any chance you did take a long chance for your clients, I am certain that you did nothing that any other lawyer would not have done, placed in the same position in such an important case. Close quote. A loyal friend, if not the most law-abiding. Most others were not nearly as forgiving. Darrow had been aided in his defense by Edgar Lee Masters, who was both a poet and a lawyer, who also assisted Darrow in the McNamara case. He wrote a poem condemning Darrow. I'll spare you the whole poem. Here are some excerpts. You are a Packard engine in a Ford, which wrecks itself and turtles with its load, too light and powerful to keep the road. A giant as we hoped, in truth a dwarf, a barrel of slop that shines in Leith's wharf, which at first seemed a vessel with sweet wine for thirsty lips. So down the swift decline you went through sloven spirit, craven heart, and cynic indolence. And here the art of molding clay has caught you for the nonce, and made your shame our shame, your head in bronze. One thing is sure, you will not long be dust, when this bronze will be broken as a bust, and given to the junk men to resell. You know this, and the thought of it is hell! So, what should we make from this? First, that Masters was not a good poet. Let's hope he was better at the law. Though, to give him his due, he did write a critically and commercially successful book of poems called the Spoon River Anthology. So maybe his anger at Darrow got in the way of his creativity. Second, that Darrow left Los Angeles disgraced, ruined, dispirited, like most actors. And he should have been, like most actors. Not only were his actions unlawful and unethical, they wound up being bad lawyering too. He thought he was helping his clients, but he ended up pleading them guilty. And many think he did so because when he found out the accusations against him, he knew a guilty plea would be evidence in his favor because, he could argue, he had no reason to bribe a jury as his clients were pleading guilty anyway. He claimed the decision to plead guilty was in place before his arrest, but the potential conflict all this caused disturbed his clients mightily. But while his clients went to prison for a long time, Darrow was a free man and practiced almost 30 more years before his death, taking on more famous cases, defending the underdog, and truly building and rebuilding his reputation to become the icon he is today. Darrow defended 11 African-American men charged with murder of a white man when they were defending the house of an African-American physician named Ossian Sweet from a white mob. In an incredibly racist era, he obtained an acquittal, convincing the jury that a black man has just as much right as a white man to defend his home. There was also the famous Leopold and Loeb case, which I mentioned earlier, in which two young rich men killed a young boy just for a thrill. Darrow, a staunch opponent of the death penalty, convinced the judge to sentence the defendants to life in prison instead. Loeb was murdered by a fellow inmate, but Leopold was paroled after 33 years in prison, so Darrow certainly did a great job for his client and expanded his fame even greater. But it was a case he took a few years later, I would argue, that cemented his long-lasting fame and reputation. The Scopes monkey trial. You have all heard of this truly legendary trial. It was about whether a teacher could be prosecuted for teaching evolution in public schools. There have been many books written about it, and most famously, the play Inherent the Wind was based on it. It was turned into an acclaimed movie starring Spencer Tracy and Melvin Douglas. And there have been 3 television adaptations, also with famous actors. Kirk Douglas, Jason Robards, Jack Lemmon, and George C. Scott were in television versions. And from that play and the movie versions, you know what this case was all about. John Scopes, a high school teacher in Tennessee in the 1920s, rebelled against the beliefs of his hick town and taught evolution in violation of the law. The local populace was furious. He was arrested. His safety and very life were at stake as the whole town wanted him hanged. Incredibly dramatic, incredibly high stakes, and incredibly false. While some of you may know this, the true story of the Scopes monkey trial will surprise many, if not most of you. While many of the players in the trial did believe important principles were at stake, that trial did not occur because the townspeople, or pretty much anyone, was outraged at the teaching of evolution in the classroom. Scopes was not arrested or charged because anyone had a religious or political agenda. No, the Scopes monkey trial was in actuality a publicity stunt. possibly the most successful publicity stunt of all time. If you go through the history that led to the trial, religious opposition to evolution was the spark. It all started with Tennessee State Representative John Washington Butler, a farmer and head of the World Christian Fundamentals Association. Butler lobbied state legislatures to pass anti-evolution laws. He succeeded when the Butler Act was passed in Tennessee on March 25, 1925, which banned the teaching of evolution. Butler later stated, quote, "I didn't know anything about evolution. I'd read the papers that boys and girls were coming home from school and telling their fathers and mothers that the Bible was all nonsense." Close quote. The bill then went to the desk of then-Governor Austin Peay. That name may be familiar to some of you, because there's a university named after him. Not to be insulting to Austin Peay University, but I believe that school is not that well known, but every now and then gets national attention for its basketball team. Like the time the Governors, yes, that's their nickname, came out of nowhere to upset Illinois in the first round of the NCAA tournament in 1987. And a few years before that, it was noted for having their top player Fly Williams on its team, which resulted in arguably the greatest sports cheer of all time. "The fly is open! Go Peay!" Governor Peay never thought this statute would be enforced, just signed it to gain support with rural legislatures. But he underestimated the ingenuity of the powers that be in the small town of Dayton, Tennessee. 2 months after the statute was passed, the ACLU put ads in newspapers around Tennessee, offering to defend for free any school teacher arrested and tried for teaching evolution. And one day, a man named George Rapelier read one of those ads. Rapelier was a New Yorker who'd been brought to Dayton to manage the bankruptcy of the once prosperous coal and iron mines in Dayton. The town had been devastated economically by the closings. Rapelier was a devout Christian, but thought religion and evolution could coexist. He'd even written letters to the Chattanooga Times mocking the new law. But when he read the ad, his thought wasn't one of defending the principle of free expression. It was helping the economy of Dayton. He thought the town arrested someone for teaching evolution and got the ACLU to come in and defend them. It could generate some publicity for Dayton. And boy was he right, more than he could have dreamed. So Rapelier heads off to Robinson's drugstore, since the owner, Effie Robinson, was chairman of the local school board. Also present was local attorney Sue Hicks. By the way, Sue was not a woman, but a boy named Sue. And it is said he was the inspiration for that song. Johnny Cash did send Hicks 2 records and 2 autographed pictures with the inscription, "To Sue, how do you do?" Also present was County Superintendent of Schools Walter White. Not relevant, but for you Breaking Bad fans out there, how cool is it that that guy was named Walter White? Rapelier lays out his scheme, and the others think it's a grand idea. But whom to prosecute? Rapelier suggests his friend and school teacher, John Scopes. So we know what happened then, right?
Well, good morning, young ladies and gentlemen. Good morning, visitors. For our science lesson for today, we will continue our discussion of Darwin's theory of the descent of man. Now, as I told you yesterday, Darwin's theory tells us that man evolved from a lower order of animals. From the first wiggly protozoa here in the sea, to the ape, and finally, to man. Now, some of you fellas out there are probably going to say that's why some of us act like monkeys. But what Mr. Charles Darwin was trying to tell us in his own way...
Bertram T. Cates.
Come off it, Sam. You've known me all my life.
Bert, you're charged with violation of Public Act 31428, Volume 37, Statute Number 31428 of the State Code, which makes it unlawful for any teacher of the public schools to teach any theory that denies the creation of man as taught in the Bible, and to teach instead that man has descended from a lower order of animals. Bertram Cates, I hereby place you under arrest.
Actually not. It was summer. School was not in session. They send out a messenger who finds Scopes playing tennis. He saunters over, no cops accompanying him. Scopes is game for the idea, and he actually thinks an important principle is at stake. Just one itty-bitty problem. Scopes was not a biology teacher, and he couldn't recall if he had ever taught evolution. The town elders were not overly concerned by this. Maybe he did teach it. And anyway, this was not about prosecuting someone for breaking the law, but getting attention for Dayton. So, Scopes was jailed.
Glory, glory, hallelujah. Glory, glory, hallelujah. Glory, glory, hallelujah. His truth is marching on. We'll hang Bert Gates to a sour apple tree. We'll hang Bert Gates to a sour apple tree. We'll hang Bert Gates.
No, nothing like that. Scopes went back to his tennis game. A warrant was sworn out for his arrest, and Walter White called the Chattanooga Times to tell them what Dayton was doing. Later, Scopes took some publicity photos of his arrest, but never spent a second in jail. Scopes coached 3 students to testify he did teach them evolution, and he was indicted on that paper-thin record. Meanwhile, the news that a small town in Tennessee was prosecuting a teacher for teaching evolution grabbed the nation's attention. The stunt was going well, but then it exploded. Sue Hicks asked William Jennings Bryan if he would join the prosecution team. Bryan was one of the most famous men in America, the first big populist presidential candidate, the 3-time Democratic nominee for president. Very religious, he believed immorality was sweeping America because of the undermining of Christian beliefs, and that the teaching of evolution was part of such undermining. His opposition to evolution had inspired Butler to propose the bill banning its teaching. Bryan jumped at the chance. Meanwhile, Darrow was asked to join the team representing Scopes. At first he declined, but then he agreed, for 2 reasons. First, he thought the principle at stake was vital. He believed the right to free speech and academic freedom was at stake. Second, and perhaps more importantly, he relished the thought of taking on Bryan. Ironically, Bryan and Darrow were once allies. Bryan had been the candidate of the average working Joe. Darrow had supported him in his first presidential run. But Darrow was a fierce agnostic and had split with Bryan over Bryan's fierce fundamentalist Christian beliefs. They had tangled in the press over evolution. Darrow had challenged Bryan to a debate, but Bryan had refused. This was Darrow's chance. The coverage of the trial got bigger and bigger. The famed newsman H.L. Mencken came down to cover it in person. Mencken had nothing but contempt for the people of Dayton, and generally the masses as a whole, thinking them ignorant. He was the one who coined the affair the monkey trial. However, evolution said humans are descended from apes, which are not monkeys. So who was the ignorant one? And then WGN Radio arranged to broadcast the trial nationwide, the first time ever for a trial. The leaders of Dayton could not believe their good fortune. This trial received more attention than anyone could have guessed. Darrow did not want to get an acquittal from the jury. He either wanted the judge to rule the statute unconstitutional or obtain a guilty verdict from the jury that he could appeal, so he tried to get a higher court ruling that the statute was unconstitutional. Thus, he made sure the jury was packed with devout Christians. The judge opened the trial with a prayer. So take a guess how he ruled on Darrow's motion to find the statute unconstitutional. Thus, the trial went on. I won't go through all the details, but the big moment was when Darrow called Bryan as a witness. Very unusual, to say the least, to call a prosecutor as a witness. But Bryan was game, and we know how that went.
Must a man go to prison because he differs with the self-appointed prophet? Extend the testaments. Let us have a book of Brady. We shall hex the Pentateuch and slip you in neatly between Numbers and Deuteronomy. Now, my friends,
Your Honor,
the witness
my
is
followers, ladies and gentlemen,
the witnesses is
all of you
excused.
know what I stand for, what I believe. I believe in the truth of the book of Genesis, Exodus, Leviticus, Numbers, Deuteronomy, Joshua, Judges, Ruth,
First Samuel, second Samuel, first Kings, second Kings, Isaiah, Jeremiah, Lamentations, Ezekiel.
Court is adjourned until 10 o'clock tomorrow morning.
Nat, dear, let's go home.
Home?
Back to the hotel.
Wrong again. The cross-examination lasted about 2 hours, and it probably depends on your point of view who, if anyone, came out on top. It was supposed to continue the next day, but the judge ruled it was all irrelevant and allowed no more testimony, which meant Bryant never got the chance to try to turn the tables and cross-examine Darrow. Indeed, poor Bryant got totally screwed because he had spoken little during the trial, waiting to give a stem-winder closing argument that he had worked on for days. But Darrow conceded guilt and did not give a closing argument, and under Tennessee law, that meant the prosecution could not give one either. Thus, Bryant never got his chance. He was going to rework his closing into a speech, but he died 5 days after the trial. To this day, people disagree about whether the trial caused his death. The jury found Scopes guilty, not surprising, since his lawyer conceded guilt, and he was fined $100. The Tennessee Supreme Court overturned the conviction on a technicality, and thus never ruled on the constitutionality of the Butler Act. Quite a tale, and one that raises some ethical issues. What do we say about a case in which the prosecution and defense conspired to bring a prosecution that may have had no basis in fact? Remember, it was unlikely that Scopes had ever taught evolution, so he probably never broke the law. The prosecutor, Sue Hicks, knew that fact, yet brought the case anyway. He also presented witnesses who were coached to say that Scopes had taught evolution. I'm sure that even back in 1925, it was illegal in Tennessee to coach witnesses to commit perjury. And if today's ethical rules were in place, this would have been an ethical violation. ABA Model Rule 3.3, titled Candor Towards the Tribunal, says clearly in Section A3 that a, quote, lawyer shall not knowingly offer evidence that the lawyer knows to be false, close quote. Hicks knew this evidence was false. Also, as I said, Hicks was the prosecutor, and there is ABA Model Rule 3.8, Special Responsibilities of a Prosecutor, which says, among other things, that, quote, the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause, close quote. Hicks was well aware that the charge was not supported by probable cause. Of course, in this case, the defendant was all good with that. Would that excuse this ethical violation? I think not. I'm sure there have been test cases where someone violates a law with the knowledge and basic agreement of the prosecution, simply so the defendant can be prosecuted and the validity of the law can be tested. But in those cases, at least the defendant did break the law. But courts don't like it when false evidence is presented in their courtrooms, even if both sides are okay with it. That act was the one that would most likely to be found as an ethical violation, although considering what was really going on, not one that I think many disciplinary panels would find too serious. And how about Darrow? He knew his client most likely did not commit the crime of which he was being accused, but Darrow made sure that fact was never presented to the court or the jury. Indeed, one reason he didn't call Scopes to testify was that he didn't want it to come out that Scopes had never taught evolution. So, is it an ethical violation for a lawyer to not present evidence or argument that he knew would acquit his client? Well, ABA Model Rule 1.2, titled Scope of Representation and Allocation of Authority between Client and Lawyer, says that, quote, a lawyer shall abide by a client's decisions concerning the objectives of representation, and, as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued, close quote. Scopes' objective was to get the constitutionality of the law tested. He didn't want to raise the defense that he had not taught evolution, nor did he want any such evidence challenged. As long as Darrow himself was not presenting false evidence or misleading the court, I don't think he was committing an ethical violation. But meanwhile, little old Dayton, Tennessee got more notoriety than it could ever have dreamed of. Its economy was not revived, but the local merchants made a lot of money for a few weeks, and to this day, people still visit it to see the home of the monkey trial. Has there ever been a more successful publicity stunt? And Clarence Darrow, at one time considered one of the most corrupt lawyers in America, ended up being considered by many as the epitome of the great American lawyer. Even poet Edgar Lee Masters changed his mind. Let me read you the poem he later wrote about Darrow. No, I'll spare you that. You've been through enough already.